Good afternoon, everyone. Thank you so much for your patience. We were clearing up some technical difficulties. A little ironic, but given the journal that we're hearing from today. But so thank you very much for your patience. And thank you all for joining us today for what I know will be an absolutely fascinating discussion of a very timely and important topic: how emerging artificial intelligence technologies are reshaping the copyright landscape. The law school is incredibly proud to support the Journal of Science and Technology in bringing together scholars, practitioners, and creators and students to explore this rapidly evolving area of law and the complex questions that are raised for courts, policymakers, and creators. I would like to thank the members who are here today joining us, the experts on our panel. First, I'd like to thank our keynote speaker, Professor Leah Bishop, our panelists, Jonathan Mann, Laura Protzmann, Professor Laura Wilson, and Matthew Topic. And of course, I'd like to extend my thanks to our very own Professor Antony Haynes, who will be moderating the panel today. And I would also really very much like to thank the journal's efforts in organizing this program today. I know how much thought you put into this program and how much work it took to put it all together and present it here today. So I'm grateful to each and every one of you for the contributions you've made to this program. I have the privilege of working with these students and their thoughtful faculty advisor, Rob Heverly. And I am so proud, so very proud of the work they do each and every day. So it is now my pleasure, to introduce Jack Rainey, the editor-in-chief of the Journal in Science and Technology.
Thank you, Dean Taranto. First and foremost, thank you for joining us today, whether you're in person or attending on Zoom. This session is being recorded and it will be made available at a later date. My name is Jack Rainey, and I have the honor of serving as editor-in-chief of the Albany Law Journal of Science and Technology, volume 36. And on behalf of the entire journal, welcome and thank you again for joining us today. The Journal of Science and Technology is a student-run publication that originated in 1990, and today we currently have 25 members. We publish articles on extremely innovative and cutting-edge topics that cover the intersection between science, technology, and the law. This year's volume places an emphasis on artificial intelligence, reflecting its growing relevance in today's society. There's truly not a better time than right now to be on the Journal of Science and Technology. Each year, our journal hosts a symposium on relevant legal issues. We strive to contribute to the discussion and and academic scholarship. For the second year in a row, we are extremely excited to host our symposium in the fall in order to bring a more timely discussion like this one today on significant issues currently impacting the legal landscape. I want to thank our faculty advisor, Professor Heverly, for his guidance and support so far this year. Without him, our journal wouldn't be able to produce such a successful volume like we have in the years past. Finally, I'm so excited to introduce this year's symposium editor. She was appointed as her role as last spring semester and instantly began planning and coordinating this event. Her diligence and professionalism has been impressive, making my job easier, and she's been an absolute pleasure to work alongside. So without further ado, please join me in welcoming to the stage Ms. Nellie Lozano.
This up a little bit. Thank you, Jack. Good afternoon, everyone. My name is Nellie Lozano, and I have the pleasure of serving as symposium editor for the Albany Law Journal of Science and Technology, volume 36. It's my great privilege to welcome you to today's symposium, which I've had the opportunity to plan and coordinate. I chose this topic last spring at a moment when artificial intelligence technologies were rapidly advancing and questions about AI and copyright were moving from a theoretical issue to a pressing one. At that time, the Copyright Office had released only part of its work, examining how AI interacts with existing copyright law. Since then, it's completed the remainder of the report, and its conclusions have only intensified the conversations around authorship and the legal questions surrounding the use of copyrighted works to train AI systems. One of the most fascinating parts of planning this event has been seeing how quickly the landscape continues to evolve. Since choosing the topic, we've seen new litigation, new regulatory proposals, and new creative practices emerge. The conversations we have today are part of a broader dialogue about how creativity, innovation, and authorship change in the age of AI. Today's discussion will be structured as a two-part program. Part one will focus on AI output, what AI systems create, and how those outputs challenge traditional copyright concepts like authorship, ownership, and copyrightability. Part two will turn to AI input, the material used to train AI systems, and how fair use, consent, and transparency shape the way copyrighted works can be incorporated into training data. Before we begin, I'd like to take a moment to thank the people who helped bring this symposium together. First, thank you to Dean Taranto for helping us begin today's program and for taking the time to be here. I also want to thank our faculty advisor, Professor Heverly, for taking the time to help me with the symposium and all of his guidance and support. I'm grateful as well to our editor-in-chief, Jack Rainey, whose support and leadership helped bring the event together, and to our journal members for their help in executing today's program. To my family and friends who have listened to me talk about this event endlessly for the past months, thank you for your encouragement. And of course, a heartfelt thank you to our panelists and moderator. Your willingness to share your expertise is what makes this event meaningful, and we're truly fortunate to have each of you here. Thank you again for being here to engage in this important discussion. I encourage you to ask questions after each segment and to join us afterward for a reception in the East Foyer catered by Novo Kitchen. With that, it's my pleasure to introduce our moderator, Professor Antony Haynes, who will guide us through today's conversation. Professor Haynes is a professor here at Albany Law School and the director of Cybersecurity and Data Privacy Programs. His teaching and scholarship focus on the intersection of law, cybersecurity, national security, and artificial intelligence. In addition to his academic role, he's a partner at Dorff, Nelson, and Zauderer, where he advises clients on cybersecurity, data privacy, AI governance, and algorithmic bias. Earlier in his career, he taught computer science at the U.S. Air Force Academy and practiced at Williams & Connolly and Quinn Emanuel in Washington, D.C. He's a frequent speaker on law and technology and holds a JD from Georgetown University and an MS in computer science from the University of Illinois at Urbana-Champaign. Thank you, everyone, and please welcome Professor Haynes.
I'm going to have to bend down. Okay. Good day, everyone. As Nellie has indicated, I am Professor Antony Haynes, and it is my pleasure to serve as the moderator for today's symposium. We have a truly fantastic lineup today. We've got professors, we've got practitioners, and an actual musician, which in an academic setting is probably the rarest species on the endangered species list. Our mission today is simple. We want to figure out what counts as creativity, who gets to own it, and whether we are comfortable letting machines riff off of our work, like that one law student who copies your syllabus but forgets to take out the comments in the syllabus. Now, some people say that AI is going to replace artists or it's going to replace lawyers. Personally, I'm not really that worried. So if AI tried to replace lawyers, I think half the briefs would be filed at 3 a.m. and the court would strike them for hallucinating citations that didn't exist. Actually, now that I think about it, maybe the AI would fit right in. So today we've brought together speakers who engage with these issues every day through scholarship, policy work, advocacy, and creative practice. They will help us to explore the landscape from multiple angles and deepen our understanding of the challenges and opportunities ahead. So in the interest of time, I will keep the introductions concise, but you can find each panelist's full biography inside of the program itself. So our first panelist is going to be Jonathan Mann. He is a musician and songwriter, best known for his Song a Day project, through which he has written and posted a new original song every day online since 2009. His work explores creativity, digital culture, and the evolving role of technology, including AI, in artistic practice, using songwriting to document both personal life and the changing technology landscape. He holds a BA in music from Bennington College and an MFA in creative writing from the California Institute of the Arts. So, Jonathan Mann. Our second panelist is Professor Laura Protzmann, who is an attorney in private practice, not professor. Laura Protzmann, an attorney at the BBB National Programs, where she develops guidance on the responsible marketing and use of AI and monitors marketplace claims involving AI tools and consumer products. She contributes to AI initiatives across the organization and brings prior experience in advertising, privacy, consumer protection, and intellectual property from both the law firm and in-house counsel perspectives. She holds a JD from Fordham Law School, an MPA from Columbia University, and a BA from the University of Pennsylvania. Our third panelist is Professor Lauren Wilson, who is an associate professor of law at the University of Buffalo School of Law, where she teaches intellectual property and property law. Her scholarship explores the legal and social dimensions of authorship and ownership in creative media, drawing on her expertise as a music theorist to analyze how musical works are defined and protected. She earned her JD from the University of Michigan and her PhD in music theory from the Eastman School of Music. Our fourth panelist is Mr. Matt Topic. He's a partner at Loevy and Loevy in Chicago, where he leads the firm's media freedom and of information and intellectual property practice. He represents a wide range of clients in intellectual property litigation, as well as news publishers and copyright and DMCA claims against major technology companies, a role that earned him recognition on Time Magazine's 100 Most Influential People in AI in 2024. He earned his JD from the Chicago-Kent College of Law. And of course, our keynote speaker, Professor Leah Bishop. Professor Bishop is an internationally recognized expert on copyright law, artificial intelligence, and human rights, and a professor at Indiana University's Robert H. McKinney School of Law. She is also an accomplished author whose work examines how law and technology can promote equity and expand access to knowledge. Her leadership on the right to science and culture has been recognized by the United Nations, and her scholarship continues to shape global policy discussions. She is widely known for her writing on authorship and AI, including recent work exploring how human creativity and judgment remain central, even in works assisted by artificial intelligence. She earned her JD from Yale Law School and her MA and BA from the University of Chicago. We are very, very fortunate to have her with us to frame today's discussion. So please join me in welcoming Professor Leah Bishop to deliver our keynote address.
Well, I have to say, I have never been more impressed with the organization of an event and just everything from the way that it was initially conceived to the just beautiful introductions. I don't know if you are excited as I am, but I am. I am just really, really pleased to be here, and I want to thank everybody. Law reviews play such an important role in the development of knowledge about law, and that's particularly true at the bleeding edge of law, when answers aren't preconceived and already known, but they need to be discovered. And that's where I think the innovation really shines. So today, I want to talk about something, a recent current event that the editors had no idea would be happening when they planned this event. And that is the $1.5 billion settlement that Anthropic, one of the 5 major players in the industry, has agreed to pay to a class of authors and publishers. Authors Guild has a website where they say, this is what authors need to know. Today, I'm looking at what lawyers need to know. And there are 2 things that I want to tell you. You know how they say, I have good news and I have bad news? I have bad news. And then I have more bad news, very bad news for the AI industry. And that is because the first point that I'm going to make is that copyright infringement can be fatal. It has the power to bankrupt major companies in a way that no other form of legal liability has. And I'm going to explain the quirky legal reasons why that's true. Given that, you might imagine that companies would be really, really anxious to pay whatever price is asked to license materials so they don't end up being sued for copyright infringement. Here's the extra bad news. This may be completely impossible, at least for large language models that need to rely on books and professional forms of writing. So let's get started. Why is copyright infringement uniquely dangerous for companies? Everybody's heard of fair use, but the most important thing that you should know about copyright law is this: statutory damages. Now, you've probably seen in other areas of law in your tort class that there can be, generally we calculate damages based on proof of actual harm, right? These are my medical bills. These are my lost wages. And then there are some areas in the law where we depart from that because of a specific authorization of the legislature. I'm going to talk first about how this usually works, and then I'm going to talk about how it works differently in copyright law. So statutory damages caps are exactly what they sound like. The legislature has passed a statute that says liability in this type of case may not go higher than this. It limits the award size by setting a maximum. And the example that I always use with my students, because it's memorable and clear, is that the state of Maryland has a statutory damage cap for the wrongful death of a pet. No matter how dearly beloved your pet is, even if they are, an exceptional breed, trained service dog, $7,500 is the absolute limit from what you'll be able to recover in court. And as you might imagine, at that low amount, it might not be worth hiring a lawyer to do so. All right. So these caps favor defendants because they are defined as at most this amount, and they're quite common actually in state codes. Copyright statutory damages sound like they'd be the same thing, but the differences are just enough to turn it completely on its head. The way that we handle copyright statutory damages is nearly completely unique in American law and every other country that I've looked into, right? Unlike the purpose of normal damages caps to limit award size, the statutory damages provisions are designed to produce higher awards. They provide a floor and a cap. So for example, in copyright infringement, we're looking at a statutorily set range of $250 at the lowest end to $150,000 at the highest end. And here's the part that really matters. That is not per plaintiff. That is not per copy. That is per work. So per book, per journal article. And you can start to realize really quickly that if you're Google Books, large language model companies that are incorporating tens of millions of works, this exposure is insane, right? It is just insane. And the computer believes it's insane. It just can't proceed. Okay, so real quick, I don't usually like to go into history, but right here, I think it's interesting and important. Statutory damages originated in copyright law at least as early as 1909. And they said, never more than 5,000, never less than 250,000. Those ranges are fairly intact today, but other things have changed dramatically. So one thing I want you to notice in the modern statute is the language the copyright owner may elect. In 1909, a judge had to use their judicial discretion to decide whether statutory damages would be appropriate. And in 1909, it said, these can't be used to punish. Those rules no longer apply. Plaintiff is entitled to choose statutory damages instead of actual damages. And although it says, as the court considers just, which sounds like judicial discretion, in fact, this power has been given to juries, all right? Plus, we have the multiplication that did not exist before. So now you have a range of jury discretion that starts at a pretty high number, if you're talking about a large number of works, and goes up to well, let me see if I can do the math off my head to give you an example. 150,000 times 1 million works, that's $150 billion, right? And there are more than 1 million books in LibGen inside these model corpuses, by far. So this is why Anthropic decided that it was in their interests to pay out one of the biggest awards ever, even though this is almost certainly fair use. And if it went up to the Ninth Circuit, I believe it would be reversed. But Anthropic can't take the risk, right? It's, you know, you've got a noose over your head and you're going to pay what you can to get out of it. Professor Pamela Samuelson from UC Berkeley is one of the smartest people that I know in copyright and computer law. And she makes the point that some companies can afford to pay really, really huge settlements. You know, quite a number of companies, but other companies cannot. So even the very large brand name, familiar, large language models, this is, well, in Anthropic's case, I think it's about 1% of what they're worth, right? So, you know, as a company, that's a lot of money, that hurts. Other companies have vastly fewer resources and yet may be using the same number of works and subject to the over $150 billion risk, right? So this is really a very weak negotiating position to be in. All right. Second problem, licensing is probably impossible for books. The publishers say we should have permission, we should have payment, this is the proper way to do it, everything will be great. All right, just a few problems with that. The Copyright Clearance Center is the largest source for clearing copyrights. So when law textbooks want to quote from something, they pay the Copyright Clearance Center. It's a bit like getting a license to cover a song. It's fairly easy to do. But the Copyright Clearance Center doesn't have the rights to do all of this. So whether any publisher, individual publisher, can sell a license to an AI company or not is going to be determined by the four corners of the contract, right? So I wanted to show you the actual contract language from my publishing contract and see if we could parse it out together and see whether we believe that that language would authorize Yale to license or not authorize. But it turns out I can't do that. So instead, I'm going to take a step over. If you are a popular book author like John Green, your publishing contract probably looks a lot like the Authors Guild's model trade book contract. So let's look at the language here. Author grants to publisher the right to reproduce, et cetera, in the formats defined below. Oops. I lost my slide that said the formats. Do you want to guess whether the standard book contracts authorize trade book publishers to license for AI mining, data mining? Probably yes, probably no. Yeah, that's a hard no, in fact. They think it's so important that they actually, put in there, and just in case you thought maybe you might have gotten the right to sell our works to AI companies, you don't, all right? That is hard no, and I'm 100% confident of that conclusion. What about, and what that means then is that the publishers are exposed to the same level of risk as the AI companies, right? So Cambridge University Press has 40,000 titles. If they license those works, and even 10,000 of them turn out to not have in the contract the right provisions, 10,000 times, it would probably be 30,000, not 150,000. That is $1.2 billion, right? So the publishing companies aren't willing to take this risk either. Got some repetition here. This is the one that we can do together, all right? So I was able to find my contract from one of Columbia's law reviews. And I want you to tell me whether Columbia Law School is authorized, whether they obtain from me the right to license my work for AI training. Yes, they can. No, they cannot. The font's small, you might not be able to see it. All right, 3.4 is the important language, right? The journal may authorize third-party publishers, aggregators, and printers to publish the article or to include the article in databases or other services. That sounds pretty promising. That's the most promising language I've seen in any contract as a license to to an AI purpose. But notice the very next line. Examples of third parties include Westlaw, Lexis, and EBSCO. Those are not like AI databases, right? So even in this most promising context, this is a completely litigable issue, and I think 60% chance an objecting author would win. For your purposes, however, as a law review, it's useful to know about this, which protects nonprofit educational institutions from statutory damages. So that big bomb, we are safe from it. Sorry for everybody who's in private practice or music, it's just the academics. So although the publishing industry is agreed, both authors and publishers and licensing intermediaries, that there should be a voluntary licensing system, they are unable to build it, right? And then think about how many different publishers there are. What if every one of those contracts is different? How much would you have to pay a lawyer to check each one of them? And more importantly, how much can you lose in statutory damages if you're wrong? And inevitably you'll be wrong sometimes. So although the answer from the court was that Anthropic had violated copyright law by downloading a big base of millions of books from this shadow library in order to feed them into their corpus, said they should have licensed that, the truth is they couldn't. That was impossible. And I think that that is important to inject into the conversation publicly today about licensing. It's not nearly as feasible as some people suggest, at least in the context of text and professional publishing. Thank you.
Thank you, Professor. Thank you, Professor Bishop. That was illuminating and exciting. So let's go ahead now and focus on part one of our panel. And we're going to focus on AI output and how these outputs are challenging traditional copyright principles. So this portion of the program corresponds to parts 1 and 2 of the Copyright Office's report on AI. And in this part, we will explore authorship, ownership, copyrightability, deepfakes, and how the emerging technologies challenge the boundaries of creative protection. So I'm going to throw the first question to the panelists to my left, your right, Jonathan Mann. Jonathan, as a musician, you have collaborated with AI tools as part of your songwriting process. When you're co-writing with the machine, how do you sort out what's your voice and what's the algorithm's voice? And what does this mean for how audiences and how the law should think about authorship?
Yeah. So I, in the last, even just in the last few months, have been using Suno a lot in my daily song a day practice. A typical song a day thing, of the last maybe 5 years would look like me sitting down, improvising a song, just getting it out, and then using like samples or something from Splice, if you're familiar with this, just a sample database that I can go to and I pay and they're royalty free and I just throw them in there and I put a song together that way. That's sort of a very typical way of making a song a day. Suno has this feature where you can upload a song that you've written and give it a little prompt and it'll build out an entire, band of things around the song. Very much like I would be doing with Splice, but a lot faster and often, with sort of genres that are very hard to pull off just with samples. So I could make something sound like Motown, like credibly like Motown, or credibly like a big band, or these things that I've never been able to approach before. And it's not a one-to-one thing. It's not the kind of thing where I can put it in and then get the output and just post it. The first thing is that it changes my voice to a voice that it does. So there'd be this whole process, and if we have time later, I'll show you, of I strip out its voice, I get the music that it gave me, I put that into the thing, I put my voice back onto it, and then often it's well, this section's not good, and so I'm still doing a lot of editing. Now, I will say though, that in the process of doing this recently, it definitely felt very different from using Splice. Even though I was doing a lot of work on these songs, there was still a piece of me that was it's not really me. There's still a big thing in my brain that was it doesn't really feel like I'm doing this. This is an active thing that I'm participating in. Even though there is this kernel of my song at the heart of it, that sort of was an open question to me. And then more recently, I got bored with that. I got very bored with doing it, and I haven't really done it in the last couple of weeks. Yeah.
Do you feel like you're co-creating? Do you feel like you're using a tool? Is it similar or different to if you had a backup band doing this?
It's completely different. It doesn't feel, using Suno in that way to me does not feel collaborative at all.
Like in a negative way, or you think you're the only musician there and the computer's not a musician?
Yes, and that, the computer doesn't feel like a musician. I do other stuff where I'm vibe coding, where I'm working with ChatGPT to write code, to write programs, to write games. that very much feels collaborative. That feels very much more like we're having a conversation and I'm telling it that it did this wrong and it's, but when I'm prompting it for music, it feels like, it doesn't feel like that. It feels like I'm just kind of pressing a button and getting a toy. You know what I mean? Like like the little things, you turn the thing and you get a toy. That's what it feels like. Like you're just getting it. You're just getting a thing. And then you can do something with the toy, but it's not, it's not it's not a back and forth.
I have a quick follow-up. I think last week there was a most downloaded song, a country song that was AI generated. And I haven't looked into it deeply, but my question is, what are your thoughts about that? And I'll stop there.
Yeah. So there was a song that was on the top of a Billboard chart last week in the country, in the country category. I looked pretty deep into it. I found the sort of source of it is on TikTok, obviously. I'm forgetting the name now, but it is very much what you would expect, and it's a sort of style of country that I think country music, this is not meant to be insulting in any way, but like there's a certain kind of country music that is very, very, very formulaic. It has the same subject matter. It has the same vibe. That's AI's bag. Like that's the thing that AI can do perfectly, is like give you just more of this thing that is very formulaic. But it's hilarious. Like you go on TikTok and you find, if you've ever seen a song go viral on TikTok, you just scroll and you see person after person after person after person lip syncing to a song, doing a dance to a song. They don't care that it's AI. They're vibing to it, whatever. And yeah, it's pretty haunting, honestly. Like I'm not happy about it. It's disturbing.
Thank you. Professor Wilson. Lauren, you study the legal definition of musical work, which in the AI era feels only slightly less confusing than trying to define organic foods. And your research highlights the mismatch between legal and artistic understandings of music. How should copyright's concept of musical work evolve to account for AI-assisted composition, sampling, production practices that blur these authorship boundaries?
Thank you. There we go. Okay. Thank you for that question. AI is yet another point of pressure, I think, that indicates that the law's concept of the musical work needs updating. And I've written about this issue prior to starting to think about AI myself. We've needed an updated concept of the musical work since like the 1960s. There's long been an incongruency between how artists conceive of what a musical work is and how the law does. So I'm going to kind of divide my answer into like my utopian view of what a musical work should be and that I've written about, and what the current law is. So I've been arguing in my work that things like timbre, which is like the way that you can tell the difference between a guitar and like a quacking duck, or it's the way that like a sound, even if you're playing the same pitch on two different sound sources, it's timbre that makes those two things sound different. So it's become hugely important in modern music. And then things like texture and production practices as songs are written in the studio. I think that those belong in most cases in the law's consideration of what a musical work is, as opposed to belonging to the sound recording, because that's how the author conceived of their work. Things like timbre and production practices are essential to what the author has written. So I think if we use that logic, it gets pretty messy with AI-generated work. A composer's input might have dictated very specific things, which some commentators to the Copyright Office's report said that like a prompt could be perhaps so specific that the output would then be protectable by copyright. The Copyright Office didn't seem very convinced by that. I am not there yet either, but it is a view that had a lot of credible voices behind it. And so you could put in an extremely specific prompt that might dictate not only the melody, the harmony, the rhythm, things that the law currently considers to be part of the musical work, but also things like, I want the guitars to sound precisely like this. I want you to layer the sounds like this. So really dictating these sorts of things that I have previously argued should be considered part of the musical work. Or an input might dictate other things with great specificity that would still kind of meet the threshold for what some commentators said should qualify as copyrightable. I think that maybe one way to look at things is my argument that we should look at what the composer intended to be part of their work. We could perhaps carry that through in an AI generated setting of what did the composer intend to command the AI to do through their prompt. But that would require us to accept that the prompt does have some input in terms of whether you can copyright the output or not. So, and I think that's an open question. And I think the Copyright Office's report gives a very good example of like a very detailed, I'm not sure if you, so they give in the prompt a very detailed example of like, draw me a picture of a realistic cat that is wearing glasses and holding a book or something. And it like gives a lot of detail about what they want the cat to look like and what kind of glasses the cat should be wearing. But once we look at the AI output that the Copyright Office put into its example, there are all kinds of things that are in that picture that the user did not specify. And we can get the same sort of issue in music as well. So your prompt might dictate some things, but not even very detailed amounts of things, but there are still always going to be gaps that the AI is filling in. So that's kind of on the law should be incorporating more things into the musical work, but AI complicates it side. If we accept the law's current conception of a musical work as just the melody, harmony, and rhythm in a piece, and then timbre and texture and other production practices as sound recording, then I think the AI-generated output gets really weird. So they think that like the premise of protecting a sound recording and whether the output, because Suno and things like that is putting out a sound recording, it's not giving you a score, correct, Jonathan? Right. Okay, so it's giving you a sound recording which has a musical work contained within it. And the premise of protecting a sound recording is, I think, similar to that of like landscape photograph or a spontaneous wildlife photograph, where we protect these sorts of things because the photographer took what was given in the physical world and then made all sorts of decisions as to like lighting and pose and text and framing and things like that. But like the thing that is the subject of the photograph was not the authors. On the same logic, we protect sound recordings in part because the sound engineer is taking what's given in front of them in the studio and making decisions as to like balance and mixing and things like that. So I think there's a good analogy to be had there. The artistry of a sound recording, like that landscape photograph, is in like the reaction of the producer to the sound source, the place, and other decisions or other things happening in the recording studio. With AI-generated music, though, the sound is 100% synthesized, right? There is no reaction on the part of the person who put in the prompt, or like the everything is being given to them. So there's no artist in the recording studio, just like there would be no like mountain for the photographer to decide how to capture. So like all of the decisions in that respect have been made. And so I think that in terms of what belongs to the sound recording that could belong to the author is really tricky. So I've raised a ton of things here. I'm not really sure that I've arrived at an answer, but I think my general argument is that copyright should be sensitive to the compositional choices that an artist is making. It's tricky to figure out what that choice is, though, in a way that it might not be in non-AI generated music. And so the prompt, I think, is one window into that. But accepting the prompt as a source of copyrighted material is also problematic and controversial, as the Copyright Office says in their report.
Quick follow-up. What is your personal view on iterative prompting? I think there may be a case out of China or Hong Kong where they allowed an applicant to attain a copyright where he had several hundred prompt iterations. And I think it's an outlier around the world. And I was just wondering, do you see that as moving in the right direction, the wrong direction?
Yeah, I think we get closer. So if because with an iterative prompt, I guess the person putting in the prompting would be kind of theoretically assuming increasingly more creative control over the work of like, you put in a prompt of just like, I want a jazz band playing a happy tune or something like that. And then you said, okay, take this happy tune and I want you to change the last 4 notes of it to go up instead of down or something like that. And, you get more and more specific. But I think that you're still kind of at the mercy of what the prompt has given you in the first place. And so, like the Copyright Office's CAT example, no matter how specific the prompt gets, there's always going to be decisions that the AI is making. And I think like it's important to try to figure out what those decisions are because the Copyright Office seems extremely unlikely to budge on the human authorship requirement. I think that has kind of been like the bottom line in so many things that they said in their report. And as your prompts get more detailed as to certain elements, I had a coworker was like trying to generate an image for a wedding invitation. And like every time we did this iterative process and I was like, just let me fix this. I'm good in Illustrator. I can do this in 5 minutes. But, he was like, no, I want to do this. And so every time he'd be like, okay, I really liked this building. Can you please add like a paneling on the windows? The AI would do that, but then it would delete the door from the building randomly. And so I think the same thing happens in the musical prompt as well. And so you could assume more creative control over some elements, but then you might lose your control as to others.
Please.
You're going to laugh. Different view of when prompted work is copyrighted. I like the way that you said, if I can put it this way, there's sort of a spectrum between very simple prompting where you can just push a button, right? And then, the really elaborate, iterative, very specific, like the Hong Kong case that you talked about. And so I think there's a question of where in the spectrum do we draw the line? And I think the answer to that might be different if we're answering what is art, what is good art, probably at the high end of the spectrum. And that might not be the same answer as what is copyrightable. Yes, absolutely. And I think if we look at that Feist standard, the Supreme Court has been saying for a very long time that if there's a minimal spark of human creativity, it's copyrightable, which makes me think anything above pressing the button, simplest prompt, maybe enough for copyright, even if it's terrible as art, even if it doesn't count as art.
And I do think a huge thing that is like looming in a lot of these conversations that like we can separate, just because we are granting the decision to grant something copyright doesn't have to be also an artistic judgment. And that's, I think, how so many of these, particularly about AI generated art, can get so heated because people have it wrapped up of like, if we're going to copyright this, that also means that we accept it as good or not so good. And that is, I think, what feels really scary to people.
Push back on Professor Bishop's suggestion about the outputs of the prompting. Would the better paradigm be to allow for a copyright in the sequence of prompts, but not in the output? So it's an assembly, it's a composition.
That's definitely true, right? Any bit of text you write, an email you send, it's automatically copyrighted. So the prompt is there. But I think people who are intentionally creating things by prompting, they don't want the copyright in their prompt.
Yep.
They want the copyright in the output. They're not going to show anybody the prompt. That's not interesting, right? We all want to look at their output. It's the output that has potential economic value. And I think there has been definitely sort of a commentary to try to say it that way. Oh, you can get copyright in the prompt. We can easily recognize the prompt as a product of human creativity. But the billion-dollar question is whether there's copyright in the output.
Well, this allows for a good segue to our only litigator in the room. Since you're the only person here who actually gets paid when AI causes legal confusion,
If we win.
I'm glad we have you. So the courts are beginning to confront disputes over AI and how it works with these assisted works here. There's questions of authorship, proof has all become critical. From a litigation standpoint, how should creators and companies document their contributions to demonstrate human authorship to defend against infringement claims?
Yeah, so let me start with two, and thank you for inviting me here. Let me start with two general principles, and I think it all flows pretty well from there. The first is that copyright law cares only about human creativity. It doesn't care about content in the abstract. It doesn't care about machine-created works. Those are worthless to copyright. Copyright cares about human expression. Okay. The second principle you have to keep in mind is what AI actually is. It doesn't respond to a command. It isn't, if you tell it to do this, I know that I will get this. Like if you were using Photoshop and you were commanding it to change the color on something. That's your expression, right? It's just executing on that. What AI is a prediction machine. It ingested, without any compensation to most creators, a massive amount of copyrighted material. And then it uses a lot of fancy math and a ton of electricity and a lot of smart engineers to create something that attempts to predict what a human would do in that situation. What would they say in response? What would the image look like if they were asked to do that? But as anyone who's used it knows, you can ask the same prompt twice and get two different responses. And that's because there's a level of unpredictability. There's a level of chance that is baked into the large language model or the image generator or whatever it may be. And so when you put those two things together, it makes perfect sense the way the Copyright Office has approached it. Because it's saying we don't care about machine-generated works. We care about human-generated works. And because humans can't control the machine, it isn't as if I was just commanding the machine to do what I'm asking it to do, in which case it's my expression. It is actually, and I don't like to anthropomorphize by saying that the machine can express anything because it can't. It's a machine, it's zeros and ones in electricity. But it is the machine that's actually doing the closest thing to the expression. That's why the cat image had things that weren't asked to be in there that were in there. There is, based on the technology now, always this degree of unpredictability. And so you don't control what the machine does. It's not your expression. I don't think we're going to have copyright protection for works that are, quote unquote, AI assisted based on what the technology is now. Now, you could have AI create a bunch of different things. You could take those things and combine them as your own expression, and you would have copyright protection over that expression. But that's something that's a little bit different. I'm just going to quote one line from the report, though, about kind of what the future may hold, and then I'll address your question. If we get to a point where if the Copyright Office is going to allow sort of AI co-created, or however we want to call that, types of works, what kind of documentation, how you'd want to go about that. So the office says, there may come a time when prompts can sufficiently control expressive elements in AI-generated outputs to reflect human authorship. If further advances in technology provide users with increased control over those expressive elements, a different conclusion may be called for. So that may happen. I'm skeptical that AI is ever going to really be that. And I think it's sort of contrary to the very idea of what AI is supposed to be. It isn't a database of works that you look up. It isn't just a software code that does what you command it to do. There's mystery, so to speak, around it. I mean, that's actually kind of one of the selling points for those who like it. If we do get to that point, I think you're going to want to document things the same way an inventor would document things in a patent context. You're going to want notebooks. You're going to want to keep very, very close records of exactly what you did. What tool did you use? What were the prompts? What were the settings? Because that unpredictability element, you can't get rid of it completely, but you can control it. It's called temperature. You're going to want to document all those things the same as if you were an inventor, on a patentable work. So I think, just to kind of sum it up, the answer, at least now, is what to document in order to get copyright on AI assisted works, I don't think you're going to be able to get it. In the future, if that changes, you need to document it very carefully.
Thank you. Great answer. So I would like to go over to Laura, and you can respond to the prior questions too, but I want to give you your cued question here. You work at the intersection of copyright, advertising, AI, consumer protection, which basically means your inbox is full of everything that can go wrong, lots of bad things. The Copyright Office's reports stop short of offering a fix for deepfakes, and yet AI-generated advertising poses clear risks for deception and misuse of creative works. How should copyright and advertising law intersect to regulate commercial deepfakes in a way that protects both consumers and creators?
So I'm thrilled to be here. I mean, my focus, as you mentioned, is less on the copyright side, more, excuse me, historically on advertising and trademark law. So I worked in-house as a marketing lawyer for many years. And now, just to give a little bit of background of what we do at BBB National Program, so we are the home of industry self-regulation. We have programs around advertising, children's advertising, privacy. And what that offers is both dispute resolution, and it's also us monitoring the marketplace to look at what advertisers are doing in terms of AI claims, whether they're AI claims that affect children, whether they're privacy considerations. So that's a lot of what I focus on in addition to other AI policy issues. So, you know, I spend, this was very interesting because, I was looking at this more from an advertising perspective, but I was fascinated by the fact that the Copyright Office in their first report actually focuses on digital replicas, which is this intersection between copyright and advertising. And they go through, they talk about the Lanham Act, which is about, covers advertising and trademark infringement. They talk about the FTC Act, all of these things that I've worked in for years, which I didn't expect to pop up in a Copyright Office report, quite frankly. And, at BBB National Programs, we are backstopped by the FTC. So what we are doing is implementing the FTC Act, and that covers false misleading advertising. It also covers things like the endorsement guides, making sure that influencers are disclosing their paid relationships with brands, for example. So when I was going through the report and thinking about how does this play out in an advertising law perspective and where might our work intersect with this, what it comes down to is when we think about digital replicas, right, you have an actual replica of a human being. That's one thing you can do, and it can be an authorized, licensed use of that person, or it could be unauthorized. Now, if it's authorized, you take a celebrity endorser and you make a digital replica and you put it into advertising and they're saying that they love your product and everything's been signed in an affidavit, you're probably okay. If you use an unauthorized digital replica, well, you've got all sorts of issues to begin with. But the other issue from an advertising perspective that you have to consider is that that's also a fake testimonial, right? Because there's this, you have a celebrity that's not actually using your product, that's not actually endorsing your product. So now you've got both, unauthorized use of a celebrity, you've got advertising issues. And then if that same, unauthorized use starts making claims about your product, then you've got false advertising issues. So very quickly you begin to see how this one issue kind of plays out and implicates various laws. It can implicate if it's if you're a consumer, there's deception. Competitors, you could be making false claims against competitors. You're fake persons now making fake claims about, real competitors. So, there's a lot of different ways where you could have issues. The other piece, which is not quite a digital replica, but worth mentioning, is that you could also just have an AI-generated human. So then you start thinking about, well, what do you have to do there? Again, you're still responsible for the same claims. You still want to make sure, you can't imply that your fake human is using the product, right? An AI-generated computer can't use your product and have a real experience, which is what's required by the FTC endorsement guides. So you start, so you have potential endorsement guide issues. And what also do you want to disclose to your consumers that this is AI generated? What's really interesting is watching how consumers have begun to react advertisers who have used AI generated models. You've seen this even in there was an issue with, I think it was a J. Crew print catalog using an AI generated model, and people just kind of lost it because they're like, this is not authentic, and it's so you quickly kind of, as a brand or as an advertiser, you start with one issue, and it quickly can spiral into a lot of other issues that you have to consider from an advertising perspective.
Thank you. Panelists, reactions, interaction?
So I loved how you said the issues are completely different if it's voluntary, agreed upon versus the opposite, right? And I want to problematize that concept a little bit. I have a law school classmate who left legal practice and became an actress, right? She's involved in the Screen Actors Guild. And she points out, if I want to work, I have to sign whatever contract they put in front of me, right? Like, it was consensual, but she didn't, she doesn't want to authorize her images to be used to act out other things. And a lot of actors are afraid that once that happens, they'll never get paid to work again. And yeah, it's a fiction in the law that if something's a contract, then the person's okay with it.
Yeah, and I think, right, I mean, do they have a choice in signing the contract? It sounds like in that instance, they don't have a choice. And then is it really, you could, right? Then you're not working. So you're kind of signing away your potential future work or not working now. So it does get very tricky from that perspective. I have this, I don't know if it's a theory or a hope. This is kind of what we were talking about before, is I think brand, especially, I come from a lot from the brand perspective, right? So thinking about brands who put out advertising material, I think the same might apply to entertainment, to movies, and to TV. I just don't think that people are going to get used to it very quickly. Now, maybe in a generation or two, we're going to have all, AI generated actors and everyone. But right now, I think you see a lot of backlash. So it'll be really interesting, I think, to see how this all plays out, because I see more backlash. I mean, there was Coca-Cola last year did this commercial. Did you see it? And it was their what is it? The holiday.
The holiday.
Yeah, the holiday Christmas commercial. And it was really well done.
Every year.
Right.
Yeah.
And some of it you might expect to be, computer generated or now AI generated, right? I don't think they actually ever use polar bears in their commercial, right? But there were human beings also in this commercial, and people there was such backlash. And Coca-Cola, to their credit, they kept going. They're still focused on AI generated commercials, but I think it's really interesting to watch the backlash. So I think obviously we have to monitor the impact to the people who are working, the creatives who are working, but I also wonder how this is going to play out.
And technologically, maybe it's not. The Coca-Cola Christmas polar bears are adorable, right? They've been adorable for a really long time. And today, any software you can call a software. So these are AI polar bears. And we're comfortable with that and been comfortable with that for a really long time. But the AI people are creepy, right? I love the way you talk about this is how this feels, right? That is real. And the law reacts to that. Juries react to that. Judges react to that.
Can I tell the Miller story? The story I was telling you guys. So I discovered this on TikTok. Actually, there's a I don't know what to call them. There's a person who has a website. It's called millers-songs.com or something like that. You could go see it. And you go to this website and you see a family, and they're sitting there in their living room, and the dad has a guitar, and there's a son and a daughter. And the story is that this dad has been making songs, personalized songs for people for 30 years. And I used to do personalized songs as part of my business. So this is sort of why it came across my radar. He's been doing personalized songs for 30 years for anyone who wanted one. And now with the rise of AI, his livelihood is at stake. And they're doing one last sale of songs to say goodbye on a high note and leave it for good because AI is taking this job of making personalized songs for people. The entire thing is AI generated. The family is AI generated. It's probably, my guess is that it's completely automated. Like people put in their people put in their things of, what is the likes, what is the dislikes. This is what I used to have a form. What is the likes, what is the dislikes? Tell me a story about the person, all this kind of thing. Hit a button, it goes in the API to Suno, and probably they take a week so it doesn't seem like it's, and they're charging people $100 to do this. And you can find people, you can find old, I saw this one video of like an older guy and his wife, and they're driving, and he's like showing his wife this like song that he got commissioned for her, and it's AI, and it's like, and he thinks it's real, and it really makes me mad. Yeah.
That wasn't like, haha, got you. That was actually.
If it was performance art, I'd be thrilled. No.
You're taking people.
Oh, they're taking people's money. $100 a pop.
Pick up on something, commonality between your comments, right? Because I also teach torts. And so I hear that and I think fraudulent inducement to contract, which is subject to punitive damages, 9 times punitive damages, right? And then you were talking about how, if an AI is misleading people to think that there's something to a testimonial that there isn't, that, I'm sorry, is it trademark law, advertising law? Where does the...
it's some, right. I was going to say it's somewhere under sort of like, it could be a false and misleading claim, right? Like if you are implying that you are a human being, that could be a new area of being it could be a false or misleading depending on what you're doing, right? It could be unfair competition. It could be, it could be a lot of things. I think that's what's interesting is, it comes up, I think, under the FTC Act and the Lanham Act. It comes up in a lot of places and comes up in what we would look at. I don't know if that there was any like false endorsement or, sponsorship or affiliation, but yeah, it's interesting because I never really thought about, the implied human as like, false and misleading advertising.
Say paid actor testimonial.
Paid fake actor testimonial is, yeah.
Yeah.
Problem.
But I think that's really interesting because often when there's new technology, especially transformative technology, we're like, oh, there's going to be all these unanswered legal questions and the law is going to have to change and catch up. But in fact, I think in many, principles of right and wrong are enduring. And sometimes it's just about figuring out in ways that aren't obvious or intuitive where in the law to look for that cause of action and that remedy. In San Francisco, I think it was this week, a Waymo ran over a cat, right?
Yeah.
And there are people who, even tech scholars, who would say, we need a new field of robot law to hold robots accountable. And I'm sitting here in my torts hat and thinking, that just looks like product liability.
I always think that's I think the Copyright Office actually did a good job of starting with the current law, right? Like, because I do think there is a lot we can do with the current law, and then that identifies, well, what is different about AI? Because there are some things that are different about it, but I think there's a lot that does get covered with our current law, and we might need the application always changes. But I did a little exercise, at BBB National Programs. I work for the National Advertising Division. We have 50 years of cases. So I've been doing a lot of AI work, looking at claims in the marketplace. And I did this kind of retrospective on all of our cases. And I went back to like the 90s on like what we were saying about things like the computer and malware and viruses and the internet and social media. And it's funny because like they went into these detailed like analysis that now you look back on it, you're like, oh my gosh, okay. Right? What is a personal computer versus a business computer? Did anyone remember that this was actually a thing, right? So, but we worked through it one step at a time, even though it was a new issue and we probably spent too much time thinking about it, but it was the same advertising principles that applied to those early days of the computer and the internet still apply to a large extent now.
I'll also say, like, I was also pretty maybe heartened by the end of the Copyright Office's report that I think we don't have a lot of answers on how to apply existing law, but I did come away from the report kind of more confident that this isn't that we need entirely new tools. We have a lot of tools that can already help, and it makes you think about like just kind of I think we're approaching kind of moral panic about AI, and there's a lot of legitimacy behind that, but we also have had very similar conversations in the context of copyright law in the past. I studied the history of sound recordings, and John Philip Sousa testified in 1907 before Congress that people's ears were going to just like die off as a result of sound recordings. And infants weren't going to be able to recognize the sound of their mothers because the phonograph was going to rock them to sleep instead. And so like those feel pretty real. Like we're not going to know how to write anymore. We're not going to know what music is anymore. You know, there are definitely some differences with AI, but the conversations are very similar. And yeah, I don't have a lot of answers for how to apply the existing copyright. You know, I have thoughts, but I think those are the open questions: how to apply existing law. But I don't know that AI is the thing that's going to cause us to need an entirely new Copyright Act.
Illuminating, right? And another one that comes to my mind is how the Copyright Office handled photographs when that was a new technology. Again, there was this moral panic. This is unfair to painters. And people like the camera will steal your soul, right? So there was a lot of overwrought there. And the Copyright Office insisted for more than a decade that photographs could not be copyrighted because the camera was doing the work, not the person.
Sound recordings too. Yeah.
Oh, really?
Yeah. The exact same thing. Yeah.
Wow.
Slow litigator wants to chime in. Matt.
Well, I mean, I hear this a lot in the context of AI that, oh, well, people said the same thing about the internet. They said the same thing about these other things. But the thing that we never really do is analyze, are we really better off for those things? What happens is we get used to them and the world continues and the world doesn't end, but that doesn't mean the world is better than it would have been. I mean, I think there's a real debate about whether we're better or worse with social media. I think there's good things about it. There's a lot of terrible things about it. And we could reach the conclusion that we would have been better off not even having the thing in the first place. So the fact that we've survived technological changes doesn't mean that those technological changes have necessarily been better. I wish I could go back to practicing law at a time when there was no email and people wrote each other letters. In all honesty, we laugh, but like, it's ruined it. It's just makes it a 24/7 brutal existence in many times. And I think back with sort of like, oh, it must have been so much better when it was like someone sent you a letter and then you had like a week to write a letter and send it. And I think they were more thoughtful and intelligent. And so I just think we need to be careful about, I mean, there are a lot of differences between AI and other technologies. And just because we survive some technological changes doesn't mean there aren't real risks we should be thinking about with these.
We could probably agree on a hierarchy, right? Like social media is the worst. No, email above social media, right? Cars. I think people like having photographs. I think that's a nearly unmitigated positive.
Well, I mean, to your point about recorded music, it largely destroyed what was a live music environment, right? Exactly. Right. And I don't know necessarily. I mean, it's like, obviously you can't go back, but what would the world be like if instead we all made our own music in our own homes? And if you went to a bar, you always had live music and it wasn't just a jukebox, right?
So this has been an awesome discussion. I feel bad to interrupt it, but I want to give the audience an opportunity to ask some questions. And because we're slightly behind schedule, if you need to do a bio break, now's your chance. And I plan for us to go into the next session in like 5 or 10 minutes. But right now, bio break/questions. So just raise your hand if you would like to ask the panelists a question, while we have our combined bio break/questioning time period. Really? Nobody? Yes.
Oh boy. So you kind of spoke about like moral panic regarding AI and its overusage. And I kind of I draw the conclusion, like the similarity between that and the point where genetic studying kind of reached a hill where it couldn't go beyond that without getting into eugenics, and that kind of thing. So I kind of just wanted to ask if you felt it might reach a point where it would need some kind of intervention similar to that.
So I can start. I do think the answer is probably yes. This is, and I don't necessarily believe all of the hype and existential risk. I think a lot of that comes from companies who want you to use their technology, but I do think that there are things we have to pay close attention to. And I think I have a big focus on sort of, we talk about the human in the loop, but I always say that the humanity in the loop, like what choices do we as humans, we are still in control. We can still unplug it all in theory, right? Like what choices do we actually want to make? And if we are potentially on this path where there's this existential risk, then we do have to, come up with some standards. And I think that is, it's a little bit tricky right now. And I wish, we're working at BBB National Programs on some self-regulatory standards to try to get industry to voluntarily agree with some third party, our like monitoring and accountability mechanisms, because, we have some state laws in this area. I don't foresee federal law anytime soon. There are some international laws, but we really need a more comprehensive international system. And we talk about things like, there are a lot of comparisons you can look to. There is, again, just like we don't need all new laws, we have areas that we can look to as examples. We have, nuclear weapons, we have stem cell research. You mentioned eugenics. Like there are instances in our history where we have made a choice to slow things down or to say yes or no to certain choices. And I think that again, it's like my hope sometimes, I don't know, that at some point we will start making those choices a little bit more clearly.
And another example might be cars, right? That was just unregulated for a really long time. Cities didn't have to put up guardrails on dangerous turns, right? And it moved from fringe to mainstream, and we started to find out that people could die. And we passed regulations that said we needed seatbelts. But that didn't happen automatically, right? There was political and public interest advocacy. And so I think new technologies do call for new regulation, even if we have the legal basis to do that regulation.
Yeah, it's a great example.
You're leaning in like you have something to say.
Well, I mean, I think the problem is that the AI debate is being couched around we're in a battle with China, and any regulation will increase the chance that we fall into totalitarian darkness at the hands of the Chinese Communist Party. And that combined with the immense amount of money and power that tech companies have make it a whole lot harder to try to do that kind of regulation than it did to regulate cars. So that's sort of my concern is, in theory, I think that's right. But in reality, it is what it is going to be, right? I mean, I don't know how you're not going to just like stop it now. I suppose you could impose a tax on the energy usage that's commensurate with the actual harm it causes, and that would probably slow down AI. I think it's actually interesting to the copyright discussion. You could say you have to pay for the content if you want to use it to train, and maybe that would actually slow things down a bit. But that's another discussion. I'm not convinced that's right. But anyway, just some top of the head reactions.
I just want to respond quickly. There's a lot of talk that the U.S. Congress and the president have been looking at a AI ban on state level regulation of AI. don't know if you've heard of this, like there's a renewed efforts on that. So I think that the tech companies are deeply worried that jurisdictions like, say, California might heavily regulate them with harm to individuals and liability statutes. And then my other thought on this is that so last month, a few weeks ago, there was a decision against Tesla for the self-driving car that ended up killing somebody. And the jury verdict assigned part of the reliability to Tesla, and I think it was several $100 billion verdict. So I think that there is something there, but it seems like we're not anywhere close to having any level of regulation you have with, say, the EPA or the FDA or that kind of level. Yeah.
Awards, I think, like they reflect the moral panic.
Yeah.
Right. This is there's a lot of emotion. There's creepy stuff, right? There's every time new information communication technologies come out, it challenges our sense of what's natural and what's icky. And I don't see an easy way to pull that out of copyright law so that we can either just apply the law or, apply policy. But I do think that whatever decisions we make about copyright, it's not going to halt and probably not even slow down the further generation of artificial intelligence. Because it's, if you're Meta, you have all of Facebook to train on. They've given permission, right? So I think we would lose probably books and journal articles, and I think the tools might be poorer for it.
Just one kind of, it's a little bit of a side comment, but it kind of goes to this training point. I know we'll probably talk about it more in the next section, but I think there is a little bit of a pushback on what we are training on. And that may be where maybe we look at different licensing models, because if you say, okay, maybe books become too expensive to train on, so we're just going to train on social media and Reddit, that is not quality content. And there's the whole, garbage in, garbage out, right? And what you're seeing, and I was... And my drive up here, I was listening to the House Committee on, I think it's Oversight and Investigations, had a hearing on Tuesday, which was a really interesting hearing because it was talking about the mental health harms of AI companions, right? Which are very often, they could be character-specific models. They could also just be ChatGPT. And one of the reasons you're seeing these issues is because the training data is so terrible that and you have these probabilistic, models that just are spewing out this stuff that is very harmful to people. So I think,
it's like if I went onto the internet
yes,
to find, okay.
Right? So like when you start seeing real harms to children and teens, then I do also wonder if that's going to force, a different conversation, because people are at least paying attention to that part of it right now. So does that then force a different conversation on things like training data, copyright, and other issues?
And I think, just really quickly, I think that highlights that copyright should not be the only tool we have to protect children from harm. Something has to interfere with these companies, because these major companies are like trains that are not going to stop. I listen to the Hard Fork podcast sometimes just to keep up on what the conversations are about all of this stuff. And they quoted Google's CEO saying, "I would rather bankrupt my company, Google is his company, than lose the AI race because of all of this competition that we're in," as you highlighted. I think we can't look to the companies to slow anything down for sure.
Okay, so I see my student editor shaking their heads, telling us to move on. So we will do so right now. What's that? We had the combined bio break, or you want to go ahead and have an actual break? So we're going to have an actual break where we're going to stop for 5 minutes. Okay, we'll come back in 5 minutes. Oh, 2. So you can run quickly to either side, and there's a restroom on either end of the hallway. Actual break. Welcome back. Welcome back. Welcome back. I hope you enjoyed your longer than anticipated bio break. So we're now moving to the second panel. Same composition for the membership, but more questions and different questions. And for the panelists, I decided to ask all of you the same question, but I will direct it to one of you first. So that way, just know you're going to chime in. And just because I have a heart for litigation, I love litigators, I'm going to begin with Matt. And so Matt, you're going to be up for this. So based on the AI and copyright cases you've litigated, what do you see as the most significant risks? So not just theoretical, but billable, right? Facing developers whose models rely on copyrighted works. And do you think existing courts and doctrines can handle those disputes effectively? Or is new legislation required to provide clearer rules?
Happy to answer that question. So I think we saw some of it in the opening presentation. The liability for copyright infringement is massive by design because it can be hard to detect, because we want to disincentivize copyright infringement, because it can be notoriously difficult to prove actual damages. We set up a regime where there are statutory damages. So even if you say $250 per work at 100,000 works, you're at $25 million. And there's a whole lot more than 100,000 works that are in those training sets. We looked at books. My clients are news. I mean, now you're talking about every news article on the internet that has been used for training. So really, these companies are betting their futures on a fair use defense. And I think they believe that that's why they should win. They believe that that courts will value their products so much to say that they'll overlook, the courts will not enter into a decision that will result in those companies going bankrupt or facing crippling amounts of liability. I think what gets missing from that is the creator side. And what the real harms are to, I'll just take news because that's what I know the most, right? Like Google search engine traffic, that's plummeting because people are going to ChatGPT, and instead of getting links from Google and going to the sites to get information and being served ads that the newspaper or digital publisher can use to pay all the reporters, that people never leave that. They never leave ChatGPT. And the citations in some ways make it worse because they give credence to what's being delivered to you, even though we know that very often those things, they hallucinate. So we may just be headed into a world where courts are going to have to decide we can have AI that's been trained on all this copyrighted stuff, or we can have a future of news that's created by people and content that's created by people, and we just have to pick which one we want. And it almost feels it's like if we feel like humanity got far enough that we can just stop creating and let the robots take over from here, then maybe we say, okay, fine, we'll live in this Sam Altman utopia on universal basic income. All right, I'll stop now. I'm sorry. To your question about does existing law suffice? I think the answer is probably yes, because fair use it's a notoriously kind of flexible standard that looks at how much is the work transformative. It's easy to say that AI is transformative, but if you look at it from a different lens, maybe it isn't so much. But really the big factor is what is the harm going to be to the market for these works? And courts are already developing really sort of three lines on that. You have one that is direct substitution. I didn't get this click because of this AI response instead. You have market dilution, which takes that to a macro level and says, is AI on the whole, and I'm talking Gen AI, ChatGPT kind of AI, right? Is that harming the overall market for news at kind of an industry macro kind of level? And then you have a third theory that is saying, well, what about the potential for a market for licensing? Would there be a market to license this content, but for a fair use finding? Because courts don't want to interfere with that if they can't help it. I recognize there are challenges in how you would go about administering something like that, but I do think it can be done, and we're going to see that in the Anthropic, class claims process. We'll know, is it Does it work or does it not work, right? Can you figure out who owns the works or not? Books, I think, are sort of uniquely complicated. They're more complicated than a lot of other content. You don't see such complicated licensing deals for like news content. It's typically either going to be written by an employee of the publisher or a freelancer under an agreement that usually is going to be like pretty straightforward. So I think to the extent Congress should get involved, it really should be, let's see what the outcomes are, and let's see if those are the outcomes that we as a society want to have. And if we like those outcomes, we'll keep them. And if we don't like the outcomes, then Congress absolutely can come in and change those outcomes. But the test, the methodology, I think does work, and it has worked over centuries, right? Not everyone loves what the outcome ends up being, but the flexibility of that really kind of allows courts to deal with individual unique situations in a way that I think is perfectly satisfactory.
Lauren, your thoughts, if any, to add on?
You can do the original question.
Sure. So the question I asked Matt was about his experience as a litigator and thinking about the distinction between theoretical risks and actual practical risks around these cases, and basically what's billable and what's not billable. And so he's looking at the existing cases and thinking about the most significant risks facing developers. So around these models who rely upon copyrighted works, and whether you think existing courts and doctrines can handle these disputes effectively, or whether we need to have new legislation to provide more clear rules.
Yeah, I think you were getting into that factor 4 in the fair use context is the most important here. And as I was reading the Copyright Office's report there, the training data section of that report is mostly walking through the fair use analysis, and you're reading through the report and everything is pretty smooth sailing in favor of fair use until you get to factor 4, and it is like extremely not smooth sailing once you get there, because Matt highlighted the kind of threads that courts are picking up on, and I think the market dilution and potential licensing market is such a problem. In music, I see it. I'm not sure if anyone has read Liz Pelly's book, Mood Machine, on Spotify. I recommend it. It's like written, it's a kind of like popular academic sort of book, and I really recommend it. And she writes about Spotify used to populate their playlists with artists, and let's say you need a playlist of jazz music, they're going to go and populate it with various jazz artists that many of us would recognize. Then they realize people are really listening to these playlists because we've created the conditions where they want to stream music all day long when they previously didn't. So now that's getting really expensive. We will put a couple of well-known jazz artists at the top of the playlist, and then we're going to hire all these ghost writers that will we can pay a much lower royalty rate to. Now those ghost writers are going to be AI writers that if Spotify is creating the music, they don't have to pay anything, right? So I think the potential licensing market, they are not only not licensing when this happens, which I think is not quite there yet, but pretty inevitable. That's the next progression of what happens with these ghost written playlists. The potential license market, we're not even licensing from the ghost writers anymore, and we're certainly not licensing from the popular jazz artists. We're taking these AI music. So I think that the fair use question is really, I would love to hear pushback on this, because for me, it's not even close on the fourth factor in terms of the potential license market and market dilution of why would I license this very expensive but very celebrated piece of music when I can get something that gets me 95% of the way there, and I'm using it for background music anyway, so I don't need that extra 5%. So yeah, I would love to hear pushback on, or other views, especially on that fourth factor. And just one other thing I'll add is it's tricky because we're kind of pitting the most important fair use factors 1 and 4 against each other, because factor 1, the Copyright Office seems to think is pretty straightforwardly fair use with training data, and factor 4, it's no, this is not fair use. Seemed to be its opinion. I don't know if other people read that differently.
I suspect Leah has many responses for Lauren. But before you hop into it, I have one. When you gave your initial keynote, you suggested I may have misheard that you thought Anthropic would have prevailed if they had pursued litigation up through a jury trial or a bench trial on the issue of fair use. And so
Not at a bench. Oh,
Oh.
wow. Not at a bench
Okay,
trial.
so
They're
I want-
clearly going to lose in front of
Okay.
Judge
So
Alsop.
I want to hear your thinking about why you think they might prevail on fair use, and then also respond as well to.
Yeah.
Yes.
All right. So that's awesome. And I read the Copyright Office's analysis the same way you do, right? And I think the Kadri and Alsop opinions back that up, right? Everybody's like, oh my God, this is so transformative, which leans really strongly to fair use. Fair use is kind of like strict scrutiny in a constitutional sense. As soon as the court says strict scrutiny, you know what the answer is going to be. In fair use, as soon as the court says transformative, you almost know what the answer is going to be. And then the copyright, there's, like you said, right? You found it to be devastating analysis on the fourth. So I'll give you some pushback, right? I think we're applying the fourth factor incorrectly. And I think the bulk of copyright scholars would agree with me that the fourth factor is the least clearly conceptualized, and that it's just messy. Like, we know how to evaluate the first factor, right? And then the fourth factor, courts are doing things all over the place. One of the problems there is that it's speculative, right? We are being asked to see a market harm impact based on the belief that there will be market harm, rather than, I guess it's been around for a while now. Somebody should check the evidence, right? But also, most fundamentally, when one person's product causes the market to buy less of another person's product, we call that competition, right? And competition is supposed to be like a type of market impact that the fourth factor doesn't look at, right? So I think that it is perfectly correct and normal for two copyright scholars or anybody to look at the fair use question as applied to Gen AI and completely disagree. And probably that's where scholarship might make a really good contribution right now, is like, how the heck are we supposed to think about this fourth factor?
Lauren, what are you thinking from the trademarks and advertising angle?
Yeah, I think I said before, I think generally the laws that we have now can be applied to this new technology. I think, and this kind of goes, I think, building on your point, what I think we need to work on is the application, right? So I think, okay, so you start with the law. We have some history on the application to different technologies, but, there are going to be differences, and we have to make sure that the law we have can stretch far enough before it becomes just kind of, inaccurate. So one example that I kept thinking of was around, copyright doesn't protect style and like brand voice. So what do you do there? Because I think this is going to be an increasing problem where you say to the AI tool, give me an advertising campaign that, sounds like, it has a, swoosh on it and, is all about just doing it. And all of a sudden, right? Like, is it trademark infringement? Is it copyright infringement? Or is it just unfair competition? And I think what you're going to start seeing is, different areas of law that then have to expand a little bit for these new issues. I don't know if copyright will ever expand that far, but then there are other areas to look to, like advertising, like maybe trademark infringement, or just unfair competition laws.
And from our one musician, I know this is not the core area, but what are your thoughts from the practitioner of the music perspective?
The thing that this makes me think of just randomly, I don't know if it's relevant or not, but the idea that Congress could make good laws about this just seems to me like, so the DMCA is something that I run across on a semi-regular basis. All my songs are up on YouTube, and I don't really understand necessarily how that law was written or how it works, but I can tell you how Google uses it, and I can tell you it's very poorly. The way that they do that law is just like from both sides of it. So I used a lot of times in the early days of Song a Day, I'd use videos in the public domain from this archive called the Prelinger Archive. This guy collected a bunch of old, public domain 50s and 60s educational videos. So I'd use those in my videos, and a couple times a year, like I'll get a DMCA notice from like a major label person who has used the same public domain video in their thing, and the system just kind of catches it or whatever. I'm sure that's not necessarily a problem with the law, but in more how they're applying it or whatever, how they're deciding to comply with the law. But from my perspective, I have very little faith, I guess, that that whatever it is going to be good for artists, I guess. Yeah.
Well, I think this really taps into broader issues around equity. And I know, Leah, you've done some research in the areas of the need for fairness and equity, and questions between how do we preserve that for creators and the communities that need to have access to knowledge. And so this is going to be ultimately for everybody, but starting with Leah, from a human rights perspective, how can policy strike a balance between ensuring fair compensation for creators and maintaining equitable access to information worldwide?
I think fair compensation for creators is so impossible that we need to stop talking about it. Right? It's incredibly difficult to implement technically. It's incredibly difficult to implement legally because you're trying to get permission from 100 million people, and the models don't work if you have permission from 100,000 people, right? And so I think that while from a publisher's point of view, that is the most important thing to get right about copyright law, I've always been skeptical that there's much money in it for creators like myself. And I've always been skeptical that if there is money for it, that I will actually see that money instead of it disappearing into the pocket of my publisher. Mm-hmm. And the Anthropic settlement is a case in point. They convinced the judge to put publishers and authors equally deserving of compensation with the 50-50 split. I think that's ridiculous, right? We didn't sign those rights to them. They didn't produce 50% of the book. It ought to be 90-10, or I don't know why my publisher's in the settlement at all, right? And I'm realizing now 3 of my books I'm not going to get any settlement money for because my publisher, although they promised in the contract to register my copyright, they did not do so. So there's always a slippage between how we want the law to work and how it ends up working. I think that's your point, Jonathan. And then I want to piggyback on what you said about this bet on betting that it's fair use. And that just clicked a light bulb for me that, we have how much total invested in 100 billion, or is it more on the scale of $1 trillion? A lot of dollars into AI technology. And usually we talk about that as, we're taking a bet on the technology. No, we're not. We're taking a bet on fair use law. That is where the risk is. And so I think the questions about news, for example, which you mentioned, is hugely important. And I think we might need to treat that in the same way that we're treating questions about art, right? Where should art be? What do we want to influence law to go in a direction, legally or otherwise, right? And I think actually that the more we talk about AI this, AI that, the AI does this, AI is doing that, that we actually lose the agency to be able to tackle and address those questions. If we shift our talking a little bit to say, how are musicians using AI tools? How is the news industry using AI tools? How should therapists be using or not using AI tools? I think framing the question that way gets us at what's important and emphasizes that we have agency in making these decisions. The technology doesn't do stuff to us, although it may feel like that at first before we get a handle on it.
Thank you. So we're running out of time, and I would like to give the audience the opportunity to ask one, maybe two questions. So if you feel there's something you would love the panel to respond to, now is your time. I see at least one or two hands raised. Yes.
Okay, thank you. Well, first of all, thank you guys all for coming and talking today. Kind of going off what was just said, I'm really fascinated by the debate on authorship. And Jonathan, you had mentioned in the beginning that not Splice, but what was the other software you were using? Suno. So you had mentioned that there was sort of a disconnect with what you were creating. Was that more you felt the art you wanted to create wasn't being executed, or was it more you felt like you were working with a robot? Like, was it creatively not, was there not a connect, or kind of if you could elaborate on that?
It was more that it's more that I felt just less involved, right? The things that it was giving me, at least at the time, as I was making it, I was like, holy shit, this is cool, or whatever. But I also, it's so, I guess like, maybe it's like a, I didn't do enough work kind of thing. Maybe it's like a Protestant work ethic, like, thing or whatever. Like, so maybe that's part of it, but just, it didn't feel the same as doing it in these other ways.
I'm picturing like a sketch artist or someone just like crumbling up a piece of paper and like throwing everything out.
And tossing it out. Yeah.
But I think I'm just wondering, how is that relevant? Because you had talked about, art is a higher bar than human expression that's required for copyright. Like, is that relevant, or is that not really relevant to the debate on authorship?
Legally not to be relevant.
Yeah, but I mean, on the completely opposite end of that, I know of people who use generative art, things in this way to express themselves. That is what they have access to be able to do it. And I don't want to discount their experience of using it. You know what I mean? That's my experience as a musician who's been doing this for, 30 years. But someone who can't play an instrument, can't record themselves, can't do any of this stuff, sits down with Suno and feels empowered by that.
Mhm.
I don't want to discount that. I don't want to tell them that what they're making is not, art, or is not something that's special to them,
Yeah. I definitely feel that way. I don't have enough art skills to make things. But in my classes now, I've been taking the cases that we're reading and creating images to go with them so I can have my memorable slideshows. The students are enjoying it. I feel creative when I do it. Like, I like it. It's not the level of art that you do, but I feel absolutely, like you said, I feel very empowered by being able to create something that 3 years ago would not have been possible in my wildest dreams.
Thank you.
One last question, if there's anybody else who would like to ask. There's a hand over here.
Thank you. So it just kind of continuing on with that is so that the accessibility that AI brings to these kind of fields, and even just in education itself, I kind of want to ask, well, I see it sometimes where it kind of creates discouragement in certain areas where people feel less need to work to like build those skills to be able to create. Do you kind of foresee any like issues with that, or just like I don't know. I kind of lost track of my question. But.
So is your question, you think that the AI is making us humans defeated, discouraged, it's diminishing our effort to create because we think why bother, or we just think the AI can do it?
Is music gonna die?
Yeah, right. I mean, there's that study, or I guess it was a study, and it's the kind of thing where it was like, you see the study, everyone's like, oh, ChatGPT is making us dumber or whatever. It's like, or whatever that was. And then I saw, the response to the study was like, oh, it's a poorly done study. It's not, they didn't do a good job or whatever. But I don't know. I with music and the people that I've seen do this, I think that they maybe just wouldn't be doing it otherwise, right? And so in my mind, at least, maybe the people who want to do it themselves, and the people who want to like have that experience of like learning to draw, or learning to write poetry or whatever it is, are still going to do that. And then there's this sort of like, lower effort way of still doing some sort of creative expression that you couldn't do before. And they're yeah, it's like, I don't ever want to tell anyone what's valid and not valid, right, as a creative expression. But we all have our own taste, and we all have we can all say what we like and what we don't like. Yeah.
Yeah, I mean, trying to think if I had a great thought and it has just flown out of my head. No, there was something in what you were saying about, I mean, there's a creativity that I think you will always have as humans, right? And then there's a democratization of creativity. I think those are all positives. I think it kind of goes actually back to what Matt was saying earlier, starting with like social media, right? Good. AI hasn't created any of these problems. AI may be making them worse, but I think at some point what we have to figure out is what are we going to do about it? Because if we're losing critical thinking skills, it's not because ChatGPT was launched 3 years ago, right? It is because of social media. It's because we've lost our attention span. It's because of other things. So I think when you say, oh, AI is creating this problem, I think you have to go back to say, well, where did it start and what are we going to do about it? Because it does surface these issues for us to think about. We just need to kind of get around to the business of fixing it.
Did recorded music kill the symphony?
Yeah, exactly. No, that's exactly right. And my good friend CJ, who's been doing AI music since 2015, no joke, like he was a very early adopter, has a great quote that he gives that I'll paraphrase, which is just like, I was generating my songs with Suno, but I felt like I was cheating, so I started using Splice samples. And but that still felt like cheating, so I started recording my own samples, but that still felt like cheating, so I learned how to play the drums, but that still felt like cheating, so I learned how to create how to build my own drums, but that still felt like cheating, so I started I started getting lambskin drums or whatever, but that still felt like cheating. So I raised a lamb up from a baby and killed it and made my own drums or whatever. I think your thing is totally right. Of like at every single step, is it better? Would we have been better off like without social media, television, the phone, radio, all of these things in their day definitely like were pointed at as being said, like, these are making us dumber. And maybe they did make us all dumber. This is the thing. Maybe they did. Maybe that, like, how far back do you have to go before you start being like, oh, that's why we're such fucking idiots now, like, right? Yeah.
But I mean, the thing that I find distasteful about the technology is it takes away the hard work of actually creating stuff, right? I mean, it's not supposed to be so simple as I have an idea for a song and then I just put it into the robot and now I have my song. That cheapens the value of the song. That cheapens the work of musicians. We're not all supposed to be able to write symphonies. It's just not how it is. And if we're creating a sort of environment in which we're okay with like mediocre AI written symphonies, I personally think we're worse off for it. But yeah.
So I think you're doing it wrong, right? If you're putting in a prompt, getting something out and going with that, problem's not the technology, the problem's the user, right? When I write with AI, it is very back and forth. It is very painstaking, and the learning curve to get good enough with the technology that I could be creative with it. It probably, I didn't have to pay to go to art school, but the time investment is there, right? And I wonder also if we would have said the same thing about the kids these days buying records.
Yeah, so I agree. Like, I think some people are better at using AI and going back and forth with the prompts. I do think, though, in my experience, what I find is that it's very kind of basic and generic. And what I worry about is that maybe you can get good at using AI. Maybe we'll all in a generation like be composing symphonies with AI or writing, historical novels, whatever it is. But for right now, I just feel like it kind of flattens the human experience, right? Because it's a probabilistic model that's trying to find like the average. Like what is producing is like the average human. And that's just like, I would like to think that, we strive to be better than that, at least, like to have that, kind of thought process, the creativity. So, I maybe we'll kind of go down that road and people will get better at this and using it as a tool. I just don't, right now, I'm not sure that the way LLMs are designed are going to get us there.
And I think like where we're at in this conversation is kind of where copyright might leave the conversation, because copyright doesn't care if it was easy or difficult for you to write the song. Like we care as like consumers of the work of authorship, like very much. I mean, like different people care different amounts how hard it was to write the song, I guess. Yeah, and that's, I think AI is like inviting us to have so many conversations about like the nature, like copyright kind of invites us to have conversation, or AI, like kind of the first place we go is, oh, what about copyright? But then AI makes us feel really uncomfortable about just what art is. And I think the conversations can get sort of tangled together. And I don't think anyone was here, but that's just like every time I've been in a conversation about copyright and AI, it always ends up, okay, yes, here's why I think AI might be copyrightable. Here's all of this. But the conversation always goes to, but I'm really concerned about the art that's going to be made, or I just don't think that the art that is being made is very good. I guess I don't quite have a overarching point there, but that I think it's just the labor piece is like clearly, even though courts have been saying for decades that, or longer than that, that like labor does not equal copyrightability. We also have like good does not equal copyrightability, and it just shows like how tricky it is that we're trying to use like a very, at least especially in America, like an economic thing of copyright is supposed to. We have a utilitarian copyright, at least in theory, but we're using that to regulate things that we hold like very dear to us, and like the human condition holds very dear.
I like what you said there. I think we'd probably be expecting way too much of copyright law to look to it to address these kinds of problems. I'm going to put something out there. I think there is a huge role for bad and formulaic art. And I'm not talking about the romance novel industry. I'm talking about children's literature. Love incredible children's literature, but kids want the repetitive stuff. It's very important to their literacy development. And the book I wrote about publishing, outside of a dozen languages, you can't get children's literature. Now you can. Right? We can translate lots of it, and we can let kids create lots of it. My kid has done this. It's not I mean, I wouldn't sit down and read it, but she thought it was the best story she'd ever read.
I think then that you have the last word on the panelists today. So with that, we'll conclude today's symposium. I'd like to thank our keynote speaker and all of our panelists for an engaging and really spirited conversation, and all of you in person and online for being part of today's conversation, and also for resisting the temptation to ask ChatGPT for the answer in real time while we're trying to analyze the questions. So there's a couple of points I want to emphasize that the Copyright Office's report and today's experts have brought up. And one of them is that human authorship is not disappearing, right? So we humans are still involved in the process of creation, and we're simply adapting to new tools. And so that understanding, the law is really trying to a lesser or greater successfulness to keep up with the technology. And the copyright report is the step in the right direction. And then third, I think all the panelists might agree that AI isn't a hero or a villain, it's a tool. And just like I can use a hammer to build a house or to hurt somebody, we can use a tool to do things that are law-abiding or law-breaking. So we humans determine the tool, and our human spirit still animates the tool, singing and writing and composing and creating, thinking creatively. All this is part of copyright. So thank you all for joining us. Thank you, Leah, Laura, Lauren, Matthew, and Jonathan. And thank you for attending this. And one thing, before we close, we invite you to stay for an additional activity, which includes audience participation, and it will be recorded for posterity. So if you don't want me to record it, step out of the camera. It's a special audience-inspired musical composition performance by our panelist, Jonathan Mann.
It will be today. So we have very little time, right? We have to like get out of here, right?
5 minutes.
In 5 minutes. We may want to do this at the reception. If people want to come to the reception, we can do the whole thing there. Would that be better? Because I don't want to like start it again.
Let's do it in the reception. Yeah.
Okay. Why don't we do it? And if you want to be part of today's song,
Love it.
and then I'll also give a demonstration if you want of like how I would put the song in just to know what that would sound like.
So East Foyer, the reception's in